Welcome back, everybody. So we were live in the Timothy Jones Jr. case out of South Carolina. The defense is continuing on with their case about insanity, trying to show that their client was insane at the time he allegedly killed his kids. But right now, a neuropharmacologist is on the stand talking about different medications, different drug use. We're going to have an opportunity to jump back live in court in a minute, but let's just go back to the beginning, when Timothy Jones Jr.'s attorneys began his defense with an admission of guilt for the deaths of his 5 young children. He claims that none of the children would have died had it not been for his middle son, Natan, messing around with electrical outlets. Let's hear from the defendant's own words what happened to his children. That is a father talking about his kids. I want to get some perspective right now, and joining me on Law&Crime is not only Terri Austin, but also trial attorney Andrew Cherkasky is with us. Andrew, I want to start with you. Your reaction to hearing the defendant. We always wait to hear from the defendant in whether he takes the stand, whether or not you hear him in a police interview. What's your reaction to listening to that?
When you hear from him and he's talking about the reaction to his first son dying, he understands the difference between right and wrong. He knows that something bad has happened. I think in the audio he says, oh, and then the S word. He knows that something bad has happened and that there's consequences to that. That's a critical function. That's a critical element in the overall insanity defense. Now, there's some uniquenesses in South Carolina, but that just shows that his consciousness of the wrongdoing is there. And it's horrific.
Terry, though, the counter argument to that is he's hearing voices. He's hearing, anytime the jury hears that, they're like, well, of course he's got to be insane, no?
Well, that's what he's saying now, but I agree with Andrew. At the time, he knew what he was doing was wrong. He knew he had killed his son. He goes to take out the other children, and he's putting them in the car. All of these are actions like he knows what he's doing. He's just saying this now to defend himself.
We watched this, Andrew, and I can't help but think insanity was the only way that they could have gone here, right? Because when you think about it, they have a guy who gets picked up, he shows where the bodies are, he admits his wrongdoing. I mean, they were very limited, his defense team, and what they could do.
There's nothing else you can do. You're raising a valid question. I mean, there are psychiatric diagnoses or psychological diagnoses that are relevant in this. It's not as though this is totally made up. There is some basis here to believe that there's some issue with his psychology, but to say that he didn't appreciate the nature of his conduct, the very low standards under the law, there's really not much of a defense here, and I don't think that there's much of a chance they're going to win. But I guess they had something to work with.
Well, look, right now we are in day 4 of the defense's case, and they say that the defendant was insane at the time he murdered his children. But the question is, what did the defendant say in his interview with police that could support that? Terry, the FBI is literally questioning him through the definition of insanity, asking him, did you know what you were doing was right or wrong? Did you know it was against the law? Did you know what you were doing? So you tell me, does that help his case of insanity or what?
It sounds to me like the defendant has been, told what to say, and that he's saying all of the right things. No, I didn't know it was right or wrong. He stopped and thought when the FBI asked him that question. I didn't know what to think at the time. I wasn't thinking about it. It just really sounds to me as though he's been prepped.
Well, Andrew, let me ask you this. We kind of heard a flavor of it. If he thought he was killing his kids because he wanted to spare them from a very difficult life, he said that he was worried they were going to have the same issues as him, and he thought he was doing the right thing, would that be insanity?
It would not be an effective defense. He has the ability to logically go through that process of deciding that he is doing something that he understands that it's not right. I mean, that's the whole point of why he's running. He realizes that he has to kill the other children because he's in trouble. He's not a good criminal. Despite the voices, despite the feeling that he has that these children are going to be burdened with this psychological effect of genetics, as he's putting it, that's still different than the legal standard that's in play here. He gets that it's not right to do under the law. He may think that there's a higher being that causes him or tells him he should do it, but that doesn't tell him he had to do it, doesn't compel him. It's criminal.
Well, let me just ask you a follow-up question. What about the fact that he spoke to authorities and admitted it to them? Couldn't that be seen as, well, clearly this is a guy, maybe he didn't really know what he did was wrong. Maybe he wanted to confess in a way because he felt he did the right thing. What are your thoughts on that?
Well, I think that what we have to distinguish here is the difference between somebody who has a genuine psychiatric or psychological issue, even if it's very deeply seated. You can have a serious mental health condition and still be sufficiently sane when you commit a crime. That's what we have here. We have somebody who's definitely struggling with mental health, but the difference is that he actually gets, at the end of the day, right as he's doing what he's doing, he gets the difference between right and wrong. He knows that it's not right. He still does it.
But it's not impossible, Terry, right? We keep talking about Andrea Yates out of Texas so many years ago. She drowned her children, killed all of them, and you could argue, those were separate actions, multiple victims, but the jury felt that was insanity. Here you have multiple victims done over one period. It's not impossible. They could come back with insanity, right?
I agree, but the two cases to me are slightly different. I think that with Andrea Yates, one, it's a mom, and I know from a perspective of psychology, whether it's a mother or a father, it probably shouldn't make a difference. But when that case was happening, she just methodically went through the killing of each child.
Right.
Here, we have someone who's thinking about the fact, wow, I killed one child. Maybe the others saw me. What should I do now? He's logically thinking about what to do next. So it doesn't seem to me as though he's really insane at the time the event was happening.
The debate ensues about insanity. Never an easy question. In a lot of the cases that we've been covering recently, insanity becomes a big question. Now, Andrew, look, I get it. It's tricky cross-examining an alleged rape victim. But they are seriously attacking her credibility. I mean, from everything from her ability to making assumptions that she thought he had a gun because of his race, to the idea of their positioning, to the idea of she had trouble identifying him in his car, to the idea of how they pointed out that she was lying about being an alcoholic. I mean, how did they do at cross-examining her?
I think this is very effective. I have the majority of my cases are sexual assault cases. And so there's some very tricky, kind of sensitive ways that you've got to go about a cross-examination. In this case, we're going to see each one of the different techniques, I think, through the different alleged victims. In this case, we have a credibility attack based on essentially a physical impossibility or an improbability of the circumstances based on how it went down. So what we have with her having to get over the fence and having inconsistent statements at the preliminary hearing, having a certain delay, having issues identifying, that all is very effective. We don't see an attorney who's yelling and screaming. We do see him parsing through the very specific issues. That's acceptable. I think if the tone had gotten heightened, if he had been more aggressive in the way that he was confronting her, then we have an issue. But this is what the justice system is about.
And now, Terry, if the jury believes that she was not credible and they don't take her word for it and they ultimately say, you know what, she made a lot of this up, it was consensual, does that affect the testimony of the other four, how they view it?
It could, because the jury could think that they're piling it all on. I think one witness shouldn't affect the testimony of the others, but it absolutely could. Here we have several of the Jane Does who didn't identify him properly. And then, as you know, there is also the claim that it was consensual. With Jane Doe number one, I agree that the cross-examination is going very well. And not only that, she just doesn't seem sympathetic. The way she's answering the questions, she doesn't seem as though she was afraid or in any way hurt. So I think that's going to help with the defense.
Well, I'm glad you mentioned that, because not only did the defense attempt to point out to the jury that Jane Doe number one possibly had a number of opportunities to run and escape and get away, but they also pointed out an instance, as Terry said, of mistaken identity from a preliminary hearing earlier in this case. Well, Andrew, it's never good for a witness to point out not only the wrong person in court, but you pointed to his attorney. What do you make of that?
It's, in this case, kind of a comedy of errors in that we have DNA that matches them, if I'm not mistaken, but it does show how unreliable she is. And so I think ultimately, when you're talking about, is this a good allegation in that it can be proven beyond a reasonable doubt, what they're establishing is that she has a claim that she's made, that she had certain feelings in the moment, that she was compelled to engage in these sex acts. What we have, though, for the defense is that the reliability of how she perceives things, how she thinks it through, it's not there. I mean, she doesn't even have the grasp to be able to put the right face to the person who did this. That's not to say that she wasn't sexually assaulted. It's to say that the reliability of her testimony and the quality of what she can present to the jury in trying to convince them beyond a reasonable doubt that it happened, it's just not reliable enough.
Yeah, it's a high standard. We keep talking about beyond the reasonable doubt. And Terry, here's the thing. If you look at all the victims, 4 out of the 5 were women of age. And that's an interesting point, because the reason I ask that, you could say on one hand, hey, all these women came together, similar stories, they all made up everything and they all came together. But the other way of looking at it is, isn't it strange that he has this kind of MO? And the fact that you have all these different kind of women, but they similar kind of circumstances, how do you think that plays? Does it help his case or hurt his case, the similarities in the victims?
I think the similarities definitely hurt his case, and I think the prosecution is happy to have all of these women testifying in the same case at the same time, because it shows a pattern of behavior. But as you were saying earlier, and Andrew as well, there's so much doubt here. And, if the standard is beyond a reasonable doubt and there's so much doubt here, then I think there's a very good chance that the defense is going to be able to make their case.
Well, we got a lot of different victims over a 16-year span, multiple incidents, and it's a bizarre case. But we're not sure which way it's going to go. We have a lot more to cover, and that's just one of the trials that we're covering here on the Law&Crime Network today. We'll take a quick break. We'll be right back.